Good morning, everyone. My name is Emily Martin. I'm NCEDA's Program Manager, and we're excited to have you all with us. Before getting started, I'd like to review the logistics of this webinar platform. You'll see on the screen a few important logistics to read through as attendees. To reiterate, all attendees are muted and will stay muted during the presentation. We'll have a live Q&A session at the end of the presentation. During that segment and any time during the presentation, you can type your question into the Q&A box. To access this option, you'll click Q&A at the bottom of your screen and then type in your question. The questions will be addressed at the end of the presentation. If we're unable to answer all of the questions live, NCEDA will send out a response sheet to all participants afterwards. The best viewing option for your screen is called Speaker View, which you'll see as a viewing option at the top of your screen in kind of the rope of buttons. This webinar is being recorded, and a link to the recording will be sent to all registrants to use as a resource. At this time, I'd like to introduce NCEDA board member John Nelms, who will offer welcoming remarks and introduce our presenters.
Thank you, Emily, and good morning, everyone. I'm John Nelms with Duke Energy. I serve on the NCEDA Board of Directors, and it's a pleasure to welcome you to the latest NCEDA webinar, Reopening North Carolina Businesses, Workplace and Employment Law Considerations, presented by Williams Mullen. This is a timely topic as North Carolina businesses, government agencies, and organizations phase back into operation and our economy begins moving along the road to recovery. I'll turn the podium over to our experts in just a moment. First, on behalf of the North Carolina Economic Development Association, let me offer my thanks to the Williams Mullen Law Firm for their sponsorship of this valuable webinar, sharing not only their expertise with us, but also their financial assistance in producing today's program. Our annual and patron sponsors are generous supporters of our professional development mission. You'll see their names and logos. On your screen now. We are very grateful to all these organizations and companies for their generous support of NCEDA and its members. We have quite a few attendees today who are not members of NCEDA. So before we get started, I would like to share a brief overview of the association with everyone. With over 700 members, NCEDA serves as the voice for North Carolina's economic development community, providing professional development, networking opportunities, and advocacy to secure the state's economic future. It is the leading association for professional economic developers and their allies and partners in North Carolina. For over 50 years, NCEDA has led efforts to promote North Carolina as an ideal destination for new businesses, jobs, and investment. One of our important roles is providing professional development and educational opportunities for our members. And today's webinar is just that, with an extended audience to include members of the business and industry community from across the state. We welcome everyone who is joining us. And now let's get started with today's program. Ted Van Duzen is an attorney in Raleigh specializing in transactional economic development and other corporate legal issues. He is with Williams Mullen, a full-service law firm founded in 1909 with offices in North Carolina, South Carolina, Virginia, and Washington, D.C. Tad is a member of the business and tax law sections of the North Carolina and American Bar Associations. He's also a community and business leader, former board member of the North Carolina Defense Business Association, and an active participant in the Raleigh-Durham chapter of the Entrepreneurs Organization, a global business network. Tad is an engaged NCEDA member, and we appreciate his role in organizing today's webinar. I'll now turn over our virtual podium over to Tad, who will provide some additional context on today's topic and introduce our expert, Mike Lord.
Thank you, John, and good morning, everybody in the audience. We have a large attendee group today, and we very much appreciate you listening in. As John mentioned, I'm a partner at the Williams Mullen Law Firm here in Raleigh. My firm and I are pleased to be able to sponsor today's presentation. For those of you who aren't aware, Williams Mullen has been and continues to be very active in the economic development space here in North Carolina. We have a diversified platform that is well suited to assisting domestic and foreign companies in establishing a presence in North Carolina. Moving to today's topic, as all of us are no doubt aware, after an extended shutdown, we're beginning to reopen the economy in North Carolina. And that means that employers are facing a number of important issues, primary among which are employment law considerations, which is the topic of today's talk. Today's presenter is my partner, Mike Lord, with whom I've practiced law for about 30 years. Mike is an employment lawyer par excellence. He is direct, he is practical, and he is highly experienced. And I think you'll find his talk comprehensive and thoughtful. With that, I'll turn the microphone over to Mike, and he can have at it. Mike?
Thank you very much, Tad. I'm hoping to get the screen up. Here we go. And there we go. With that little glitch, good morning, y'all. Again, my name is Mike Lord. I'm going to be your leader as we walk through a survey of issues you'll face as we put North Carolina back to work. We could spend a lot of time on just a few slides, but I'm going to try to be respectful of your time and try to move through that slide deck. As mentioned, there will be an opportunity for questions at the end of the presentation. As we begin, it's one of those things that you check yourself. Whether you open your business is not entirely your decision. You're going to need the government's permission. Think of it as the final license that you need or the final permit that you need to operate your business. And like all things, there are strings attached and it won't be free. Right now, under the governor's phase 1 order, which is in effect until May 22nd, there are a number of guidelines or conditions on which businesses may reopen and how they operate. There is no indication that the governor is going to make any other changes until the May 22nd deadline. It seems like these are going to be the conditions we're operating under for at least the next week, despite some pushback from a number of sources. This order removes the designation between essential and non-essential businesses. So we're no longer putting people into different camps. But thanks to those essential businesses, because now we have the benefit of thousands of laboratories where they, through trial and error, have developed best practices that are reflected in the conditions that we'll see in the governor's order. The businesses that weren't allowed to operate by name still aren't allowed to operate. Much to my chagrin, on that list is barbershops and hair salons. And so I still have to have my hero haircut that has really grown out. Now, the last point on this slide talks about businesses may operate, and that's something that I do want to underscore with you all. Whether you open your business or not, now that you're allowed to, is still a question, and it's a good question for many people. Clearly, as a practical matter, you're going to need the confidence of your employees to open. You're going to need the confidence of your customers to come shop. You're also going to need the help and support of your supply chain partners. So what may be legally permissible, there's still a practical aspect about reopening your business. Is now the time to do so? If not, when is? But one of the big takeaways from this talk, I hope, is that there are a number of issues that you need to address, and the only way to do that is through a plan. Make it a deliberative process and a collaborative process with all those stakeholders. Now, under the governor's order, all businesses are strongly encouraged. So it doesn't really have the force of law, but it has the bully pulpit behind it. Not only does this governor's order contain these types of conditions, you'll see those throughout the country. So if you do business across state lines, you're going to see a number of these factors that are woven into a bunch of these orders. And it's the same type of information that you'll get from the federal government too. First and foremost is to continue telework. So if you can continue doing business remotely, keep it up. It's something that people have been surprised about their capacity to be able to do this type of work, but it's been a welcome surprise. The other thing that has become ubiquitous now is the 6-foot rule. So businesses, as they reopen, are now putting painter's tape on the floor saying, here's 6 feet. I think by the end of this crisis, when we come out at the other end, we'll have a very good idea of how long 6 feet is. And it's almost like one of those full-size shopping carts that you would get at Harris Teeter or Food Line. But there's this separation, and it's a good reminder of people to be cognizant of the danger and to stay outside the 6-foot zone. The next bullet point about having no more than 10 workers gathered together, that's consistent with the rule about mass gatherings. That number may be coming down as time goes on. Clearly, there's always this issue about personal hygiene, that this is a personal responsibility that people ought to discharge without any kind of feedback or pushback. The next issue here is in the governor's order that he recommends what he calls face coverings. These are the things that you see on the news and you see walking up and down the streets. We'll get more into whether this is personal protective equipment in a later slide, but you'll see at least the governor recommends that folks use them and recommends that employers provide these types of coverings to employees and train them how to use them properly. Another part of the strongly encouraged list is to make accommodation for workers. The governor's order in this sense is redundant of federal laws, including the Americans with Disabilities Act that we'll touch on in a later slide. Certainly the next bullet point doesn't need a whole lot of discussion. Sick workers ought to stay home. They shouldn't even come to the workplace. It may be a function of them needing the paycheck, or maybe a function of, even in this age, lack of education or awareness that their symptoms are problematic and they ought not to be a potential spreader of the disease. So with that, you'll see that the governor is encouraging employers to give this baseline education to folks so they know about it, and there's no reason why they would knowingly try to infect the workplace. And there are, of course, opportunities for folks who are beyond normal stress to reach out to people who can help them through this crisis. The next slides are going to talk about retail businesses. And so the governor has given some details, specific details as to this sliver of the economy. I'm not going to spend a ton of time on this, and I hope you just don't ignore these slides if you're not in retail, because there are some good practices here that are applicable to your workforce. One of the first things out of the gate in the governor's order about retail businesses is that they can only invite half the amount of foot traffic into their stores. So that again begs the question, is this the time to open the business? Do I need more than 50% of people of capacity to make my business run? If it doesn't make economic sense, then why step into the situation only to have to close the business because you don't have enough traffic? And this next slide again just reiterates the 6-foot rule, the common sense recommendation to make sure that you're cleaning with the right products, and that you have hand sanitizer available as you enter or you leave or throughout your retail store, and clearly also in the bathrooms. Here's a recommendation that a lot of folks are doing that have already opened their doors, is to do basically a well check with their folks. What I've done is taken the state's sample checklist and provided it for you to see. Really, there's only two questions. Have you had close contact with someone who's been diagnosed with a positive COVID-19? Yes, no. And clearly, we know what happens with those answers. And then, how are you feeling? Do you have fever, chills, shortness of breath, new cough, loss of taste? Many employers have more detailed type of checklists, and it would include recent travel. It would also include other types of contacts with folks. So there may be an outbreak at another facility located nearby that a spouse may be working at. And so there are additional questions. This gets to be problematic because anytime you start asking people how they feel, it's a medical inquiry. And that's usually a stop sign for employers not to ask those questions. But if you do go forward with asking those questions, then the question becomes, what are you going to do with the information? And then lastly is, once you have the information, you have to treat it confidentially. So there are a number of issues that come out of taking this step in screening employees on how they're feeling. One way that many employers are handling this is just to educate folks about what the symptoms are and ask them not to report to work. So it's something that we don't get into as employers asking these questions. We just ask the employees to do the right thing. The next slide, immediately send symptomatic workers home. That's a no-brainer. Know what to do once this perhaps inevitable situation occurs, and then post signage throughout your facility to let people know what to expect and how to act while they're in your store. These other things are good type of controls for retail workplace, and again, it can be transferred to yours to designate certain shopping times for seniors or other high-risk folks, and to have one-way aisles or at least a good traffic flow so people don't crowd together. And then finally, we've already seen this adopted, and you can't miss it in your grocery stores where there are shields protecting the folks who are ringing up your grocery items, and also with the signage on how to get through the store. So these are basically the conditions that we're living under. Another kind of no-brainer takeaway from all this is you need to keep current on what the government requires, what the government recommends, because every day brings a new fact. And what's frustrating about it is that this may be conflicting. So what the governor's recommendations are may be conflicting with what your OSHA mandatory requirements are. And you also get contradictory type of guidance. So one day the CDC will say something, say face coverings aren't necessary. In a week or so, that recommendation changes. So there is, since we're dealing with this in real time, you need to understand, you need to be flexible through this crisis, that there will be conflicting, there will be contradictory recommendation. You just need to do your best to remain calm, make some good decisions. The key point on this slide is that COVID-19 is not gone. It won't be gone on May 22nd. It won't be ruled by any particular date on a calendar. It's something that we will have to live and work with for the foreseeable future until there's a vaccine. So I want to pause there and set those expectations. We had been working under a regime where we were trying to flatten the curve. We were trying to flatten the curve in order to allow our health system to provide services to all those who needed it. Now we're beginning to try to flatten another curve, and this curve deals with the unemployment. In both situations, we need to look at certain data points, and now the data points are being expanded to include not only the health information, but also the unemployment information and getting people back to work. So we've entered this new phase, and we have to understand the realities of it. So part of your responsibility as running a business or helping counsel them is to remain current on what the advice is. You ought to have the cdc.gov bookmarked and check it on a daily basis to see kind of what else is there. Because as I mentioned, the CDC does update its information, and we'll see that it doubled the list of symptoms very recently. And if we flip back to the earlier slide, you'll see that not all these symptoms are on the sample medical screen put out by the North Carolina Department of Health and Human Services. So there's a lag time between this type of information. And we have the EEOC issuing guidance, reissuing guidance, pulling it back. And so there's been fits and starts on some of the government agencies on how they're acting. Same could be said about OSHA. In the midst of all this, you need to be prepared to address employees' concerns consistently and uniformly. Honestly, when you say, "I don't know," that's a good response, and it's a truthful response. I don't know about you, but this is my first pandemic, and as Tad mentioned, I've been kicking around for 30 years now, and still I learn something new on a daily basis. So I think you need to be frank, honest, candid with the folks. And if there are questions you can't answer, just admit it. I think you will have much more credibility going forward if you take that particular stance. So during these times, management needs to be visible, needs to be engaged, and needs to model the expected behaviors in order for us to have a successful reopening. As a fine point, there are new employee rights on paid leave, and that's accompanied by a new workplace poster. As you open up your shop, this is a new poster you'll need to download and put out for folks, usually in the break room, so they can learn about their rights. And remember that this idea of open and continuous communication isn't limited to one audience, meaning your internal stakeholders. It's also to the general public. They want to know how you're handling things. It's going to be your customers and your visitors. They want to know before they arrive what to expect. And so those are other communication pieces for you. Now that you've made the decision to reopen, the next question is, who will join you on the field? And so you need to right-size your workforce. Many people aren't going to start back up with everyone coming back to work on day one. They're usually going to be a skeletal or an essential worker type of start, and then from there you'll build by adding people on. Understand that this is going to be a change from where you were before the outbreak, and just accept that, deal with it. One of the questions is going to be whether you continue the furloughs. So who's going to be brought back, in what capacity, for how long? And then what would be the next phase in going through this? As we talk about furloughs, and we also see layoffs on this slide, understand that most people may use these terms interchangeably, but there's a legal difference. A furlough is an unpaid leave of absence. So for those folks who are going to continue on this status, understand that there has been some openings here where it used to be that people on furloughs, if they were given any money, it would count against their unemployment benefits. There's an accommodation made now that if employers want to make some gratuitous payments, it's going to be okay. And there's also opportunities for employers to create kind of crisis funds. So it would be a tax-free type of vehicle to allow employees to pull money out of a crisis fund to meet some urgent demands. Say, for instance, an unfortunate situation where you had a funeral, it's really an unexpected expense, and maybe you can draw down from that. So you can try to be creative in helping your workforce. If you are going to downsize your operations and you convert furloughs into layoffs, a layoff is the end of the employment relationship. Understand that you're going to have to provide employees with a particular notice about the Department of Employment Security about their services. So this is a new requirement, a piece of paper that has to accompany the pink slip. Also understand that if your layoff is large enough in size, you may trigger some notification obligations under the Federal WARN Act, and that if you do try to provide severance in exchange for a release, there are certain disclosure hoops you have to jump through and some mandatory consideration time periods that you have to provide in order for that release to be valid. We're now going to pivot to engineering controls. And what I mean by that is, what can we do to our workplaces to make them better, safer for folks? That's not going to rely on really them to do the right thing. It's trying to kind of make it idiot-proof, for lack of a better phrase. And clearly consistent with the governor's order, you increase the physical space between employees. You can do it through physical partitions. There are also, there's great technology out there on the market. Basically, you have employees wearing what looks like is a watch, but really it sounds an alarm if you get within 6 feet of another person wearing a similar type of watch. So make sure, just kind of think outside the box, and that for all the good that technology provides, look out for these types of options. Ironically, a beneficial secondary benefit may be a decrease in sexual harassment claims if we keep people apart. So always trying to look for the silver lining. When it comes to common areas, we either shut them down or remove the seating so you don't have more than 10 people in a room. It may be even less if you can't comply with the 6-foot rule. Work outside. The virus doesn't survive that well outside, so if you can do some things outside, go ahead and try to do that. One of the takeaways from this crisis is going to be a situation where we're no longer going to have those cool collaborative workspaces where you just have a long table and lots of extension cords for people to plug in their laptop. This may be the end of that type of work environment. As mentioned in the governor's order, we continue to allow people to work remotely. One of the things about this crisis is the genie out of the bottle? I used to spend lots of hours defending employers when they said, we can't allow people to work remotely because we need them there to build the team. We need them there to manage the team. We need them physically present for other types of legitimate business reasons. Those excuses may ring hollow after this crisis. So it's going to be an interesting effect to see how this rolls forward going from here. Of course, folks are going to say they need to work remotely. That's basically code words for asking for a reasonable accommodation under the ADA for their disability. And the only way you can't allow that is if you show undue burden. Right now, the EEOC is very solicitous toward employers on this undue burden. As soon as the crisis starts to abate, you can expect that the flexibility that the EEOC has on undue burden is going to vanish. So just be mindful of that. And one thing that has been a blind spot for many folks is that if you do allow telework or you encourage it, is how is this work being done? Is it not only being done in a safe manner, is it being done in a secure manner? Have you suddenly lost your ability to protect your key confidential information because someone is not using the right equipment? So IT needs to step up and address any hole that you may have for teleworkers. The next slide is going to deal with administrative controls. This is changes in policies or practices. So what can we do to make a safer workplace? You can have staggered shifts. So again, this way you don't have people on top of each other. So if you can have them come in half hour later, leave a half hour later, that way we don't have the mass exit at the end of the day. And we also leave break rooms a little bit more open. So that's one type of administrative control to consider. Another thing is that now that people are working from home, some of them are going to like it. And they're going to like the flexibility that's involved by working at home. So you may see more requests for accommodation asking for this type of flex schedule. Once again, you'll have to defend it, or you'll either have to accommodate the request or you'll defend it on a undue burden type of analysis. When it comes to meetings and travel, again, consistent with the governor's order, if it can be deferred, do so. Remember that if you do have a workplace that caters to the public, you're also going to have to think about how to serve them safely. And so we've seen all sorts of very creative and ingenious ways to serve the customer with no contact or very little contact. Again, you can adopt those as you see fit. As promised, we're coming to the PPE slide. As a little backstory, I do a lot of OSHA work, and PPE flows very easily off my tongue. It was something that people didn't understand. It was just kind of legal jargon. But today, it's a term that people readily understand, and there's no reason to dive any deeper into it. But if you allow me just a personal privilege here, it used to be before COVID-19 outbreak that there were respirators and there were things other than respirators. Now we have a new lexicon where we have face coverings. Again, remember what the governor strongly recommended for workplaces is face coverings. So face coverings are something that aren't a barrier between you and the rest of the world that reaches a certain level. So anything that covers your face could be a face covering. Once you get into some serious types of PPE, like the face pack, the face mask, the ubiquitous N95, that's a respirator. Once you get into the respirator category, you have graduated into something that's a serious issue. That there are specific OSHA regulations governing how it's used, by whom, requiring medical surveillance and all sorts of other hoops to jump through. So the dividing line seems to be today between face coverings, which don't have all those OSHA requirements, and a true face mask. So understand the difference there, and also to understand that a face covering, honestly, is not for self-protection. So it could give an employee a false sense of security. I look at a face covering as more as a tangible expression of goodwill, that I may unknowingly have the virus and I respect you so much, I'm going to put a face covering on so I won't infect you. But one of the challenges is going to be for management is to educate folks about what exactly a face covering is, what it does do, what it doesn't do, and also how to wear it. Again, I have a hard time watching the news and seeing people put something across their face and think that they're safe or that they're helping someone when the face covering is upside down, doesn't fit, isn't covering the nose, again, it's something that you'll need to educate folks on of here it is, here's what it can do, here's how to wear it, here's how to clean it, and if not, we provide it. And my recommendation is to get it right, we need to control the process. So I would encourage folks to supply the face coverings and to make sure that they're cycled out at normal times. Make sure that people know how to use them, wear them. But when you get into face masks, your responsibilities are laid out much more strictly with the OSHA respiratory protection standard. And then finally, there are other PPE out there. And so gloves, face shields. Many people don't understand that a face shield may be a good alternative to a face covering. Some people may feel claustrophobic or may have some other issues on the face covering where a face shield may provide the same type of benefit. And of course, there's goggles, these protective aprons, there's all sorts of things. Since you're going to be responsible for providing them, paying for them, and otherwise maintaining them, make sure you have enough supply on hand. That's a challenge nowadays that I think is getting fixed as the supply chains are opening up. But you don't want to get in the situation where you only have a day's worth of face coverings and you're asking people to continue to work without it. So what are some kind of modifications to the terms and conditions of employment that folks are going through? One is this reduced work week. This allows us to be able to have more people getting a salary, albeit maybe a smaller salary, but at least everyone has a chance to get back to work. There also may not be the need for everyone to work, so the work week may be a shorter thing. When it comes to reduced salaries, understand that there are a lot of legal hoops to jump through. Make sure if you're going to reduce salaries that it's on a prospective basis, that it's in writing, that you give at least 24 hours notice of the reduction, and that there are certain thresholds you can't go below when reducing salaries. For hourly folks, you can't go below the minimum wage, and for exempt folks, you can't go below $684 an hour. The next bullet point is the hazard pay. Really, there is no such thing. You may find it in a union contract, you may find it as a condition of a government contract, but there is no legal requirement to pay any extra for working in a supposedly hazardous workplace. You're going to hear this more and more. This has been a complaint about from a number of employees, and it's something that you better be prepared to address. Even though I said it won't be a legal issue, you can say, all I have to pay you is minimum wage, or all I have to pay you is the salary I told you I was going to pay. But the law of supply and demand kicks in here and may trump that. You may have to pay people more to get them to come back to work. And then there's going to be an issue. If you do have work available, you do encourage people to come back to work. What if they refuse to? Is this a situation where you're going to say this is job abandonment? Or are you going to dig deeper to find out what the reasons are for their refusal to come back to work? If it is this disability type of issue, there are some obligations on our end to make sure that we try to accommodate people. So what about some other nuts and bolts of the employment relationship? Folks, you may have to turn back on the accrual of vacation and PTO. It may have been suspended while you were not working. You may try to seek to recover the employee share of benefit contributions that you made during this time. Are you going to call this an advance of salary? Are you going to try to get an authorization? If you do start taking money out of people's pay, make sure that that net pay doesn't fall below minimum wage. So there are a host of issues in recovering these funds back from folks. Vacation, scheduling vacation and PTO use. The last thing that you want is to say, we're up for business. We're gonna want you to start to work June 1st. And the first thing you know is on excuse me if I said January, on June 1st. And the first thing you get is a request for vacation for the first week in June. So that's a problem you should see, anticipate, and deal with in advance of it. The same thing with your benefits. Many people may have exhausted their vacation just to have money. And now we're just beginning the summer season. There's Thanksgiving and Christmas. What are you going to do with someone who's already burned through their vacation? There also may be gaps in coverage caused by furloughs. Since they weren't working the minimum hours per week, they may no longer have been eligible for the benefit. What are you going to do when you onboard laid off employees? Is there going to be a break in service for these folks? How do you deal with that? How do you avoid it? You have incentive comp plans that probably are shot because you've now been out of work for 2-3 months. Are you going to revise your bonus plans? And then finally, something to consider is to leverage your group health benefits. Again, think outside the box, especially in this day and age of being out of work for so long. All you see on the news is bad news. That this has a toll on people's psyche. So you will find, if you ask, that many carriers have been proactive here. That there are no costs for certain tests, or no deductible for certain tests, that doctors are available to be visited through your smartphone. And there has been also carriers who've allowed coverage during furloughs, even though employees aren't meeting the minimum hours. And certainly let your folks know about the EAP benefits that usually accompany group health benefits. It's a great benefit. Let them know about it. Encourage them to take advantage of it. One of the things that you'll need to learn to process is a request for the new federal paid leave, not only on the front end with employees, but also on the back end to receive your credit. Some of the things we aren't going to change when we reopen. We're always going to be involved in this interactive process when people come to us and say they don't want to come back to work because, and they fill in the blank with a health reason. This is going to be your hardest issue to address. And it's something that you ought to anticipate, and you ought to kind of think through, what is my red line? What is my undue hardship? Am I going to make someone come back to work who claims that because of their pre-existing conditions, say diabetes, that they're especially vulnerable to the disease and can't work? Is there a way to make them not customer facing? Is there a way to isolate them from other folks? Is there a way to keep them teleworking? These are all issues that are going to be a struggle for newly opening businesses. Understand that every crisis does have its boogeyman. So that during the AIDS crisis, there was some fear, prejudice, hate directed toward the gay community. 9/11, you had the fear, prejudice, hate directed toward the Muslim community. For COVID-19, there's going to be this fear, prejudice, hate directed toward Asians or Chinese in particular. Be aware of that. Make sure that this type of nonsense doesn't happen in your workplace. So you're going to follow your non-discrimination policy also when you recall people back to work. Follow whatever system you come up with. Either it's merit-based, it's a needs-based, some people do seniority-based. It can be a combination of all those types of factors. But just don't play favorites, because in that sense, discrimination can easily creep in. Big bullet point here: respect protected and concerted activity. Many people say, I don't have a unionized workplace, so I don't need to be concerned about protected and concerted activity. That would be a very big and expensive mistake. The law applies to all workplaces, regardless if you're unionized or not. Understand that a new dynamic out of this crisis is that employees feel empowered and have found their voice to protest. Remember, this is America, And the right to protest is not only encouraged, but it's protected. So you're going to see people complain about their working conditions, complain about their pay, complain about the protection that's being involved, try to either strike, walk off, or reach customers and try to shame you into doing the right thing. This is a very dangerous type of situation to deal with, and avoid the knee-jerk reaction of saying, you can't do this and you're fired. Again, that's going to be a very expensive mistake for you to make. And finally, avoid retaliation. Folks are going to be able to be involved in a lot of protected activity. Say, for example, take their paid sick leave, take their child care, ask for accommodations. That sets you up for a retaliation claim. So what you can do on the proactive side is, again, be engaged, talk to folks, try to get ahead of these issues, solicit concerns and address them. The medical surveillance, again, this isn't required by the governor's law, but some people are out there doing this. I ask you to think this through before you start the process, because again, it's going to be a type of inquiry into someone's medical condition, and you can see the host of questions being asked here. They need to be thought through before you engage in this type of screen. Clearly, when there is a suspected case, you should know the drill by now. Employee needs to be removed. So then you try to do some tracing to find who's been in close contact. You put folks out for self-quarantine for 14 days. You clean behind it. But then there's the inevitable questions. Is this OSHA recordable? Is it reportable? Should I make it a workers' comp injury? All sorts of questions there. The other questions that are open and still to be answered because they're not addressed by the governor's order, but events will take care of that. When testing becomes available, are you going to require testing? Testing only tells you whether you're positive or negative at a given time. What about the antibody testing? Is that going to be available? If so, are you going to use it? Are you going to condition people, your employees, to have the testing done before they come back to the workplace? Are you going to require this to see the underlying document? Or are you going to rely on self-reports? When it comes to testing, think of it as a drug sample. If someone's disappointed in the test result, are they allowed to retest? At whose expense? The same sample. Lots of questions involved here that we're going to have to work our way through. When we do reopen the workplace, there are going to be any number of folks who are coming back to us. There are going to be recalled teleworkers. There's going to be reinstated furlough people. There are going to be people who have been sick, who've been healed. There's going to be people that we rehire and onboard as laid off employees. And then we have conditional new hires. Are we going to have any type of medical screen, any kind of qualification before these folks are returned to work? If so, what does it look like? When the vaccines come down, are you going to require that as a condition of employment? There's going to be people with medical objections to it. There's going to be people with religious objections to it. How are we going to handle that? And also, how do we screen visitors or customers? These are all types of issues that we'll need to work our way through. But of course, there's one certainty that I can tell you about, is that there's legal exposure in all this. Not to scare you, but to at least give you some kind of awareness and parameters. The first type of legal exposure is going to be, you killed my Mima. You at the nursing home did this. You at the airline did this. You, the limo service, did this. Or you, the employer, got my husband sick. He came home and my mother then got ill because of that. The only way that this theory is going to move forward is going to be showing a lack of reasonable care. What is reasonable care? That's a great question, because as you see, the governor's order has a lot of advice, a lot of recommendations. It doesn't have the force of law. There is no OSHA standard on how to deal with COVID-19 specifically, and there's no OSHA standard to specific industries. So people are kind of feeling their way around here, relying on the CDC and other government recommendations that may set the standard of care. We don't know that for sure, but from a constructive, proactive standpoint, that's why you need to know what the government is requesting or requiring and what the government is recommending. The more that you can meet those recommendations, and certainly the best that you can meet the requirements, the better position you will be to defend one of these things. The next type of exposure is not going to come from a third party or an outsider. It's going to come from your workforce. It's going to be one of these things where I got sick at work. Well, how's that handled? Typically, it's a workers' comp claim, but it's very difficult to prove a COVID-19 is compensable occupational injury because of the causation. You know, what's the link between you working here and getting sick? How can you prove you got sick at work versus getting sick at the grocery store, getting sick at home, getting sick somewhere else? So to ease that burden, we have legislative solutions. So one of the things that's being floated in downtown Raleigh is to make it a presumption that first responders, healthcare workers, and other essential service workers got sick at work to make their burden that much easier to prove. That is being hotly contested, not only in North Carolina, but throughout the nation. And it's an issue to look out for, to see how you manage that liability. Are you going to do it in the workers' comp arena? Are you going to do it in the normal civil courts? The other claims that you're going to get is retaliation. I mentioned to you before that workers now have their voice and are making complaints. They do so, and then later on they're fired, their hours are cut, whatever. You're going to get a claim for retaliation. You're also going to get a claim for not being paid time work. What do I mean by this? That if you have these medical screens before you begin to work, you can imagine this long line outside your doors of people waiting to get their temperature checked. And they're going to claim that they should be paid for this wait time. So understand that that's another risk that you need to manage. We spoke about people coming to you with their concerns, and it's going to involve medical information. So who do you tell? When you do you out these people when you do the contact tracing for a possible COVID situation? Do you treat the medical information lightly, or do you make sure that it's treated very, very, very confidentially? So there's a specter for a breach of privacy type of action. And there's also already been big class actions against cruise ships, food processing facilities, universities, including the North Carolina university system, for all sorts of claims. Because of this environment, and I hate to mix metaphors, crisis metaphors, but you know, we have the COVID-19 issue, and now we're going to reach back to the tsunami of lawsuits, and that has traction for many in the business community. Mitch McConnell in the United States Senate is making this a very high priority, and will attach it to the next stimulus bill. Understand that this is going to be a highly contested issue, but employers are looking for the rules of the road. It's always been that way. No one's looking to hurt people. And if you just give them the roadmap of how to operate their business, they're more than happy to do so, as long as they're shielded. We can move forward. So that's the next legislative battle that you will see. And of course, there's going to be issues of people not being able to keep their promises to you. So there's going to be litigation about broken contracts. You're going to be looking at new clauses in your new contracts to make sure that you anticipate another type of pandemic. And finally, there's going to be litigation around insurance. You bought a business interruption policy, and now the insurance company isn't standing behind them after you've paid the premiums. That's an issue, and that may be litigated. So With that, let me turn it back over to John with any questions.
Thank you, Mike, for all that helpful information. So much about this pandemic has presented dramatic changes in the way all of us live and work, and it's reassuring to have access to legal insight on the issues we need to navigate as we move forward. We have a few minutes for Q&A now. Our participants have submitted questions via our Zoom platform, and we'll go to those now. First question, you mentioned earlier in the presentation, Mike, an employment poster. Where can folks obtain that?
You can go to the federal website. It's going to be US or DOL. Just type in DOL and it'll come up. It'll be under the wage and hour division. But if you just type out CARES, C-A-R-E-S, poster, Federal Department of Labor, you'll get that pop up.
Okay, thank you. Second question, employees and PPP and unemployment insurance benefits. What do I need to know and what do they need to know?
So on the unemployment front, if you do have to let someone go because of this crisis, it's a much easier type of discussion than in times past. So you'll let the employee know, honestly, we can't carry you on because we don't have the revenue. We need to let you go. You need to provide the employee with a piece of paper which describes the services available from DES, encourage them to make a claim for unemployment, encourage them to make it very clear in the application that this was COVID-19 related. And then on our end, in our response, when there's a request for information about the separation, we make it very clear up front that this is COVID-19 related. So it will expedite the claim processing and the employee will get his or her benefits and hopefully also get the benefits from the federal contribution. I hope that answers the question, John.
Yes, thank you. Another question. What remedy does an employer have vis-a-vis an employee if the employee comes to work infected without knowledge of the employer and infects the employee base?
The remedies are very, very limited. The remedy is to fire the employee on a rules violation theory, because by this time, you've educated your workforce about what the symptoms are. You educated your workforce, don't come into work. And lo and behold, they did. You come to find out that, yes, they've been sick. They were going to come to work either because they needed the money or for some kind of deliberate, mean-spirited thing. You would then say, you've broken our rule, just like you break any other rule. So that's the way it would be treated. How sympathetic you would look is another question. Whether you would be able to prove it or not, who knows? But that's your remedy. I don't think you would have a cause of action against the employee for something beyond that. Again, because we get back into this workers' comp issue, is that claims between employers and employees are going to be handled through the Industrial Commission, and everything else, for the most part, stays within the commission. And so this just wouldn't be a claim that would be made.
Okay, I got one more question. There is a symptom overlap between allergies and COVID-19. Should an employer try to distinguish between the two or just default to sending the employee home?
Absolutely. So when this first rolled out was when all the green stuff covered my car. I'm an allergy sufferer. So if you were going to start telling people to go home once they sneezed or they had runny eyes or blowing their nose, that would be an overreaction. So I think, like most things, this is a common sense approach. And hopefully in most things that you can trust your employees. You trust them with all sorts of other things. Now you're trusting them with the operation of the business and the health of their coworkers. If you do take that aggressive stance and say one symptom alone is going to be enough to basically furlough the person, you may not have, as a practical matter, enough hands to do the labor. So also understand that one symptom alone doesn't mean that you have the virus. So if you take temperatures, even though it may be a high temperature, that does not mean automatically that the person has COVID-19. So this is a rule of reason type of approach where I would default to the medical opinion. So if you do have a doctor that does your workers' comp type of claims, this is a good discussion to start to have, is to say, what really are my thresholds here? Is it one symptom? Is it 2 or 3 symptoms? I need help because I know how to run my business. I'm not a doctor. So that's the approach that I would take.
Okay. I want to thank you to all of our participants for those thoughtful questions, and thank you again, Mike, for the timely and valuable answers. We've come to the end of today's webinar, but at NCEDA, the learning never ends. We have 2 webinars lined up for next week that you will not want to miss. On Tuesday afternoon, May 19th at 3:30, we will feature a panel of economic development research experts discussing finding the right data method and comparing workforce analytics and community data tools. Moderating that panel is longtime NCEDA member and economic development thought leader, Crystal Morphus. That's Tuesday afternoon. We also are excited to announce that next Thursday morning, May 21st at 10 a.m., our friends Mark Vittner, Chief Economist at Wells Fargo, and NC Bankers Association President Peter Gwaltney will join us for a program entitled From Recession to Recovery, Assessing the Economic and Financial Impact of the Pandemic. EDP-NC's Chris Chung will moderate that panel for us. Electricities will be our sponsor that day, and our thanks go out to them. Again, that's next Thursday morning, and we'll open up registration today. Watch your email for additional details and registration information on those programs, and we'll have more virtual professional development offerings in the pipeline for this summer. Thank you again to Williams Mullen Law Firm, to Tad and Mike for their leadership today. You brought some important issues to us, and NCEDA appreciates the benefit of your expertise. We also appreciate the ongoing support of our patron and annual sponsors for their pivotal support for the organization's mission 365 days a year. Folks, there's much more on the horizon. We hope to see everyone online and hopefully in person soon. In the meantime, stay connected, stay informed, stay confident. Most importantly, stay well. Thank you.